My name is Anna Triponel, and for discussion today, what are responsible contracts? Well, first, what are contracts? It's funny, contracts can feel like technical legal instruments and not very exciting, but contracts are actually incredibly powerful. I loved negotiating contracts for companies when I was a lawyer. They govern everything that companies do. In short, contracts govern the relationship between two entities. What is each party committing to do? What happens if things don't go as planned? How can one of the parties walk away from the relationship? As a lawyer, you're trained to think through, how can I best protect my client, the company that I'm working for, through this document that we will sign with the other side? A number of contractual provisions are typical in contracts. We ask the other side to promise legally that they are in compliance with our expectations, our standards, and that they have told us everything we need to know. That is what we call representations and warranties. We let the other side know that we reserve the right to verify that things are going as planned. Audit rights. We might have penalties in place for suppliers to compensate us if things don't go as planned. And we reserve the right to walk away. Termination rights. The issue is that these things we're used to putting into our contracts as lawyers don't work well to tackle human rights issues. Why? Well, they don't reflect how human rights impacts actually happen in the world. Certain human rights impacts occur by virtue of operating in certain contexts. And with the best will in the world, one supplier alone is not going to change that. One time I was working with an apparel company with Chinese suppliers. They all had signed a contract stating, we have no overtime. The apparel company thought, this is strange, because it's very common in China. So the company removed the provision from the contract and asked the suppliers again, tell us, but without contractual penalties attached, do you have excessive overtime? 95% said, yes, we do. So some contracts set suppliers up for failure from the point of signature, since they are in breach the minute they sign. Another reason traditional contracts don't work for human rights is that the way a buyer runs its own business can make the supplier's compliance with the contract harder, sometimes even impossible. This is referred to as purchasing practices. Once I was traveling around Thailand working with suppliers, and they all said to me, the buyer's lawyers have asked us to sign these contracts guaranteeing all these things, but then the buyer changes the orders at the last minute without extra payment. So yeah, we do have to ask our workers for more overtime, and we have to subcontract to, let's say, factories to make the delivery of goods on time. Another thing that happens with traditional contracts is that the buyer often forces its own human rights priorities onto the other side, which may or may not be the most important human rights issues to be concerned about from that supplier's perspective. We saw this a lot with the Modern Slavery Acts. A number of suppliers shared with me that the resources that they had started to allocate to tackling issues that they were seeing come up, discrimination or land rights, for example, all of those have been reallocated to report up on modern slavery to their buyers who are subject to these disclosure laws. So, in other words, the contracts dictated the supplier's human rights priorities, which may or may not have been the actual priorities to prioritise when looking at the severity of human rights issues in that workplace. So now that we've established that traditional contracts don't work well for human rights, what do we mean by responsible contracts? Responsible contracts are structured and negotiated in such a way as to meaningfully seek to tackle the risks to people that can arise. By risks to people, we mean human rights risks. So it could be, health and safety issues or land concerns or forced labour, discrimination, that kind of thing. In fact, responsible contracts are drafted and negotiated in a way that is aligned with the UN guiding principles on business and human rights and are based on a deep knowledge of the human rights issues we are trying to tackle in the first place through the use of the contract. What does this look like in practice? First, we request that the business partner puts a human rights risk management process in place with certain minimal standards. This is about incentivizing the supplier to manage human rights risks as part of their own systems. Second, we consider what it would take for the process of cascading down the value chain to be meaningful. Through the contract, we are cascading the responsibility to respect human rights, but we're not cascading a tick box attitude. Third, the buyer plays a role too. This is a shared responsibility. Suppliers are asked to put these human rights risk management systems in place, while buyers are asked to support this and not make it harder. Fourth, remediation of the actual impact is prioritised over penalties and termination, which may benefit the buyer more than the actual people involved. Suppliers are asked to look to remediate the impacts that arise, which could entail a role for the buyer as well. Fifth, remediation and dialogue are prioritised over termination. Suppliers and buyers work together to tackle the issue rather than leaving suppliers in the lurch. Of course, there are some exceptions where the buyer might need to disengage, and in this case, responsible disengagement is on the cards. This is covered in another video. For anyone trained in contracts, it can feel overwhelming to do things differently, and let's face it, a tad unrealistic given the need for legal certainty and to protect company interests. But increasingly, legal certainty and company interest means tackling the human rights issues at hand, rather than undertaking an allocation of risk exercise. I can assure you that this is the road ahead for any lawyer working on human rights in contracts. Take a look at the ABA Model Contract Clauses 2.0 on the topic, or the work of the Business and Human Rights Lawyers Association, for example. Thank you for watching, and see you next time.